Copyright, trademark, fair use are some of the different types of intellectual property that we discussed in the previous topic. Although these types are very different, people often confuse them. So in this video, we will talk about intellectual property, patents. So what is a patent? A declaration issued by a government agency declaring someone as the inventor of a new invention and having the privilege of stopping others from making, using, or selling the invention of the claims. Governments grant these exclusive rights in exchange for the clear and detailed public disclosure of inventions. In order for an invention or innovation to be patentable, the invention must satisfy the 5 requirements. The first requirement is that the patent's subject matter is patentable. The categories for patentable subject matter are defined as broadly as any process, machine, manufacture, or composition of matter or improvement thereof. The Supreme Court has interpreted that anything under the sun that is made by human beings is patentable. However, the distinction here is that innovation has to be the product of human inventiveness and not the product of nature. The second requirement for patentability is that the invention is useful. Understanding patents requires a little more technical expertise. The third requirement for patent protection is that the invention is new or novel. Basically, if somebody else already invented or patented a similar invention, you can get a patent. The next one, the innovation must also be non-obvious. And lastly, the final requirement is enablement. Technically, this means that the specification of the patent shall contain a written description of the invention and of the manner and process of making and using it in such full, clear, concise, and exact terms as to enable any person skilled in the art to which it pertains to make and use the same, and shall set forth the best mode contemplated by the inventor of carrying out his invention. There are 3 types of patents. First, the utility patents. The 5 requirements we just talked about refers to utility patents. Second, the design patents. It protects only the ornamental appearance of an article and not its structure or utilitarian features. Apple is famous for their design patents and their utility patents. Lastly, the plant patents are granted to persons who first notice the distinctiveness of a plant, then reproduced or asexually by grafting or cloning rather than growing it from a seed. So, what rights does a patent give? A patent also brings the right to take legal action against others who might be infringing and to claim damages. And an inventor is not required to get a patent in order to put an invention into practice. But once the invention is made public, there will be no protection against others using the invention, and you would be unable to obtain a patent. The Intellectual Property Office does not ensure that others do not copy a patented invention. It is up to the owner to take any necessary action to ensure an idea is not infringed. Once granted or in the public domain, any ideas may not be re-registered. So, in conclusion, the basic purpose of patent law is to promote technical innovation and commercialization. A patent protects inventions. These inventions can include new and useful processes, machines, manufactures, compositions of matter, as well as improvements to these.